Welcome to today's Family Law webinar on family law matters involving children. We hope that everyone is doing well, and we thank you for joining our discussion. First, I would like to introduce our presenters. We have Susan Lichterman, who is the practice group coordinator of the Family Law Group at Jaffe. She has over 30 years of experience, and she specializes in all aspects of family law, including divorce, custody, parenting time, and support. Susan also does some appellate work. Next, we have Jennifer Latosh, who is an equity partner in Jaffe's Family Law Group. She has over 20 years of experience and similarly specializes in all aspects of family law, including divorce, custody, parenting time, and support. Jen also does some probate litigation work. My name is Michelle Younger, and I'm an associate in Jaffe's Family Law Group. I joined the firm 2.5 years ago, and I have over 10 years of experience. Prior to moving to Michigan, I practiced law in New York City, representing children in abuse and neglect, juvenile delinquency, custody, parenting time, and guardianship. We would like to cover a few housekeeping items before we get started. Everyone is placed on mute during the webinar to prevent potential background noise. If you have any questions or comments, please submit them at any time via the Q&A box on the bottom of your screen. Time will be allocated at the end of the session for questions and answers. Just a general disclaimer that due to the governor's and the health department's most recent order, Jen and Susan are working from home, and we hope that there will be no internet or connectivity disruptions. Our agenda for today covers initial custody determinations, parenting time schedules, child support, and common post-judgment matters. First, let's start with a polling question so we have an idea of what people are most interested in today. So on your screen is a polling question. Please click on which area you are most interested in learning about during today's question session. Okay, there we go. It looks like people are most interested in common post-judgment matters. Thank you for your feedback. Just another general disclaimer, this session is meant to be a general overview and is not meant to be specific to any individual case, and we are available post-webinar to address your specific questions. Jen, can you tell us a little bit about initial custody determinations?
I would be happy to, Michelle. Thank you. And thank you to everyone for joining us today. It's good to be with everyone and talking about the general issues regarding kids and family law matters. And as Michelle said, that we're more than happy to talk about any specific questions or concerns that you might have after today's webinar. Talking about the initial custody determination, in Michigan, what the courts will use is the Child Custody Act of 1970, and that pretty much lays the framework of what the court is supposed to look at regarding the best interests of the kids and whether parents, and then they'll look at also whether parents are married or divorced. So for married parents, what the courts will first do is they can put together a custody arrangement regarding when the parents are separating during the underlying divorce case, and then they can put together a final divorce or final custody order once the couple is divorced and the entry of the judgment of divorce. For non-married parents, it's a little bit different. The first thing the courts need to look at is who is on the birth certificate. If the father is named on the birth certificate, either the mom or the dad can initiate a custody action to determine custody. If the father has not been named on the birth certificate, the first thing that needs to be done is to initiate a paternity action to actually ensure that the father is the legal father and then move forward with custody and parenting time. For jurisdiction, the courts want to make sure that they actually have the ability to decide these custody issues. So they are going to look at whether or not the child has lived in Michigan for the last 6 months. If the child is under 6 months of age, they're going to look at if the child actually lived in Michigan for the duration of their life or for the majority of their life. And as long as that the couple lives in Michigan and the child is in Michigan, the family court in Michigan was going to handle all custody and parenting time issues.
Susan, could you tell us about the different types of custody?
But first, I should unmute myself. Absolutely. Again, welcome everyone to the third in our three-part webinar series. Here in Michigan and in most states, there are two types of custody. There's legal custody and physical custody. And legal custody is the making important decisions about your child, and generally it's educational, medical, and religious decisions. And I would say 95 to 99% of all cases, the parties have joint legal custody. And it doesn't matter if the child is primarily living with one parent. If you have joint legal custody, that means you share in important decision making, like where your child goes to school, whether your child gets vaccinated, other medical decisions, and religious decisions. But even in those minority of cases where there's sole legal custody, the other parent is still allowed access to educational, medical, and religious records. That parent just isn't permitted to make the decisions about those issues. And then physical custody is what it sounds like, basically where the child lays his or her head most nights. And it's the schedule. Is the child primarily with one parent or primarily with the other parent? Is it 50-50? Is it 60-40? Is it 70-30? But the fact that it's can be called joint legal custody, and that doesn't necessarily mean that it's 50-50 and that the child is equally with both parents. You can have a joint physical arrangement where the child is nevertheless spending more time with one parent than the other parent. And there's no one set rule or schedule in Michigan. There have been over the years many attempts to pass legislation for there to be a presumption that in every case there will be 50-50 custody. That is not the case here in Michigan. There's a presumption that we're going to do what's in the best interest of the child. And when there is a dispute as to physical or legal custody, the court has to start first with what we call the established custodial environment. Often we abbreviate it the ECE. And that means where the child has been up until this point of his and her life. Who does the child naturally look to as for comfort and parental guidance? And often it's with both parents. It's certainly in a case of married folks who have been living together with the child. Usually when we start off in the established custodial environment is with both mom and dad, both parents. But why it's important to address the established custodial environment, and we'll get into this a little bit later, because that determines your burden of proof. If the established custodial environment is only with one parent, that parent is going to have an easier time getting sole legal or physical custody. But again, when we're starting from scratch, that initial custody determination, generally speaking, the ECE is with both parents.
Jen, can you tell us what factors the court considers when deciding which parent should have custody?
I'd be happy to, Michelle. In the Custody Act that we talked about earlier, the Child Custody Act, there are actually a list of 12 best interest factors that the court is required to look at and consider before making a final custody determination. Now, this is something that the court will look at in making the initial custody determination, or if down the road in a post-judgment matter, there's a request for a modification. And if those certain hurdles are met and the court is looking at custody again, they will look at these 12 best interest factors. So it's important to note that not every factor will necessarily be weighted equally when the court is looking at these. And it's also important to note that more often than not, both parents will factor equally in these different factors. So not every factor is equal when you add them all up together. And generally speaking, both parents do generally weigh pretty equally on all of the factors. But these are things that the court has to look at when they're going through the case before they make their determination. So the first one they're going to look at is the relationship between the parent and the child. Who does a child go to if they have a problem? Who does a child go to if they're excited about something and want to share? That kind of gives an idea to the court of the relationship between the parent and the kids. The next one is the ability of the parent to provide the guidance and the ability to continue their education and their religion. So who is responsible, or who has been more responsible for going to parent-teacher conferences, or making sure that discipline is enforced, or taking the child to church or to religious classes. They'll also look at the ability of the parents to provide food and clothing and medical care. So this can run a lot of different gamuts. It can be who has the stable employment and can provide financially for food and clothing and housing. And it also applies to who is more responsible for taking the kids to the dental appointments and who's responsible for making the eye doctor appointments and things like that. Another one that they're going to look at, number 4, is the stability of the environment. So does the parent have a safe and stable environment? Do they provide continuity of care so that there's not a lot of turmoil in the child's life? Also, the permanence. I'm sorry.
It looks like we had a question just come in related to the court.
Oh, sure.
Somebody is wondering, at what age does my child get to decide who he wants to live with?
Well, there is, down on the next page, there is going to be an ability for the preference of the child that the court will take into consideration. There is no magic age in Michigan on when a child gets to decide. The child's preference is actually one of the 12 factors that the court can consider. The older the child, the more weight it may have, but it's important to know that the child is not in the driving seat on this one. It really will be up to the judge. But the older the child is, the more weight that may have for the judge in making the decision. So there is no, unfortunately, magic age. Looking at also down the list, we have the moral fitness of the parents. We often get questions on this one as well. If a parent is having an affair, that's not necessarily going to impact this particular factor very much. It would only come into play for, say, if one of the parents is having an affair with the babysitter, that involves a child. Or if one of the parents decides to hire their girlfriend or boyfriend to be the babysitter, that might be involved. But just mere fact of having an affair is not necessarily going to have an impact on the moral fitness factor. It's more in line of, is there a drug or alcohol abuse, or is there a significantly impaired driving record that might harm the child in some way? That goes right into the mental and physical health of the parents. This is the mental and physical health if it impacts their ability to care for the child or properly provide the guidance and the love and the care that the child may need at home. Looking at the home, school, and community record, again, this is the parent that's more responsible for going to parent-teacher conferences or more responsible at working with the doctors and the counselors and the teachers, who has that connection to the child's community. On the next slide, we will see the continuation of the 12 best interest factors, and this is where that reasonable preference of the child comes into play. It's very important to note on this one that the child will never, especially in our area of Michigan, take the stand or testify in a trial. What would happen here is the judge and one of their staff members would meet with the child. Under normal circumstances, they would meet in their office, in their chambers. Now they might go for a walk or meet at a park or take a stroll around the courthouse due to the COVID concerns. And this is an opportunity for the judge to really get an idea of what the child is feeling and thinking about where they would like to live. This is not something that the court will report back to the parents. They will take it into consideration in making their overall determination, but the judge is not going to provide that information or break that confidence with the parents, but they will take it into consideration. And again, the older the child, the more weight it may have, but it's not going to be the ultimate determination. A big one that the court is going to consider is the willingness of each parent to foster the relationship between the child and the other parent. Does one parent encourage the child to go see the other parent for parenting time? Does one parent try and thwart going to the parenting time to see the other parent? Not answer the phone, not let the child communicate with the other parent. This is a really big factor that the court will consider, as it's really important that both parents foster the child's relationship with the other one, not to denigrate the other parent in the presence of the child, and to really encourage a strong relationship between both parents and the kids. Domestic violence, whether it's been inflicted upon the child or upon somebody in the child's presence, if the child witnessed domestic violence, that's definitely something that the court will want to know and will take into significant consideration when making the ultimate determination. And then we have a catch-all, a factor 12, if the court should consider anything else. This may be if the child has special needs, and one parent is better suited to provide guidance and assistance for those special needs, and anything else that the court might need to look at. So we can wrap that into factor 12. One of the biggest things to consider when looking at an initial custody determination is that it's generally speaking best if the parents can reach that decision on their own. It's not always possible, but it's always important to at least try, either through negotiations with attorneys and the parties to try and reach that final resolution, or to go to mediation and have a third party kind of guide and assist parties in reaching a mutual agreement. Any family that can make that decision on their own and not be dictated to how they should be raising their kids are more likely to honor the agreement and to be a continual team for the kids. If you have to go to trial, and it's always, it does happen, we do have to do that occasionally. If you do have to go to trial, it can really impact the ability of the parents to co-parent after that. Trials are difficult, they're expensive, and they're emotionally draining. And when you're talking about ability or inability of the other person to parent, that can really damage any ability to co-parent moving forward. So if the parties can reach that mutual agreement either on their own or through the assistance of a mediator, and they can stipulate to the custodial arrangement and the parenting time schedule, then that's just presented to the court, and the court will review that, make sure that it actually does meet the children's best interests, and then they'll enter that order. If not, then it will proceed to a trial, and the judge will take all these considerations into their minds when they're looking at the final determination, and they'll enter a ruling, and then both parties have to honor that. The friend of the court in the area is willing, and it will often meet with the parties and make a recommendation to the judge. So the judge has a little bit more to go on just than the testimony and evidence presented before them. It gives them some guidance, and it can also help provide the couple in reaching a mutual agreement if they can. The last option would be arbitration. Sometimes people may not want to present all this in public, in a public format. So arbitration is an option, and this is similar to mediation. It will be a neutral third person, but that person would have the ability to actually make a final award and determination about custody, as opposed to sitting in front of a courtroom with a judge. So those are the different ways you can get to that final determination of custody.
Thank you, Jen. Susan, could you tell us what the courts look at when determining parenting time as opposed to custody?
Absolutely. So again, the court again looks at the Child Custody Act. The court again, for parenting time, considers what is in the best interest of the children. And sometimes, as family law practitioners, we try very hard not to get caught up on labels. And joint physical custody is one of those labels that we don't have to be overly concerned about. You want to make sure joint legal versus sole legal, that's a big difference, as I previously mentioned, whether or not both parents participate in decision making. But as to joint physical, it really doesn't matter what the label is, because what's important is the parenting time schedule. So we can call it joint physical, and we can have a variety of different parenting time schedules. And building on what Jen said, it's always best to settle and determine your own schedule and your own and what's best for your family and your children. Because when we settle, especially on a parenting time schedule, we can be creative and we can have the schedule that works best for your child, your children, and your family. So in addition to the best interest factors that Jen outlined, there are also some parenting time factors that the court may look at, but the court is not required to look at. And the first of those factors are the existence of any special circumstances or needs. Obviously, if a child has special needs, any sort of a disability or the like, and one parent is better able to care for that child and to address those needs, that's going to be something the court considers. Whether the child is nursing and under 6 months of age, obviously that's for a brief period of time, and that would, of course, favor the mother. The reasonable likelihood of abuse or neglect during parenting time, that's very important. And it doesn't only refer to abuse or neglect by a parent. If a parent is in a new relationship, if that new partner poses a threat to the child, that's something that the court's going to consider. The inconvenience to and burdensome impact or effect on the child due to traveling for parenting time. We'll talk about this in a few minutes about the distance between the parents, but if one parent lives far from the school, if the parents don't live close together, that's something the court's going to consider when creating the parenting time schedule. Whether a parent can reasonably be expected to exercise parenting time. Is the parent going to actually use the parenting time allotted to him or her? The threat of actual withholding of the child from, or concealing the child from the other parent. And again, this goes to that best interest factor of the willingness to facilitate or foster a good relationship with the other parent. So the court is going to obviously, if concerns about a parent not facilitating parenting time, that's going to affect the schedule. And once again, we have the same catch-all that we have with custody, any other relevant factor that the court can consider. But as I said, next slide, please. There is not one schedule. It's not one size fits all. There are some common schedules that we use. If it is a case where it's 50-50, that the parents are having equal parenting time, it can be week on, week off, and that is better for older children. They don't always like packing up and going back and forth, easier sometimes, especially now with remote school. But for younger children, that's not always a great schedule to go a full week without seeing one parent. So in those situations, we have sometimes come up with what we call the 2-2-3 schedule, and that is one parent 1 week has Monday, Tuesday, and the other parent has Wednesday, Thursday, and then the next parent has the weekend, and then the following week we flip with the other parent having Monday, Tuesday, and the next parent having Wednesday, Thursday. Some parents find this very difficult, the back and forth. Other parents love it. And then there's the 2-2-5, and that's where the same parent always has Monday, Tuesday, the same parent always has Wednesday, Thursday, and the weekends are rotated. And these are just examples, and there can be many other different I always say when I started some 30 plus years ago, it was mostly every other weekend and a dinner on Wednesday night. And it was generally the dad who had every other weekend and dinner once a week. That's a very rare schedule these days. Generally, we have the weekends generally go till Monday morning. The weekday will be an overnight. But again, we're going to look at and fashion something that works best for you and your family. And then those schedules are what we call regular parenting time, the parenting time week in and week out during the school year. And we also have holiday vacation and school break parenting time. Generally, we're going to rotate the holidays. And again, we can fashion this to what fits your family. If one side of the family always celebrates Christmas Eve and one always celebrates Christmas Day, we can award one parent Christmas Eve every year and one parent Christmas Day every year. But in the cases where the parties can agree, the court's just going to alternate. Almost every county has a standard parenting time schedule. In even year, one parent gets Christmas Eve. In odd years, the other parent gets Christmas Eve, and down the line. And of course, with the religious holidays to fit your religion. In families that have parents celebrate different religions, that's always easier for us. I mean, it's always easier to give the Jewish parent Passover and the Christian parent Christmas. So we're able to do that. And then we also have, as the kids are in school and older, their breaks from school, again, can be alternated or divided. Generally, a break that's a week or shorter is alternated, even odd years, and the breaks that are 2 weeks or longer are divided in half. We then usually have a different summer schedule. Some parties continue the school year, but each has a couple weeks of vacation. Some have a completely different schedule in the summer. So again, up to you. And if you can figure it out, always best. If not, the court will.
Now, moving on to our next topic. Jen, can you tell us how the courts determine child support?
Sure, I'd be happy to. So in Michigan, unlike parenting time, we have a little bit less flexibility in working through the child support. we have what's called the Michigan Child Support Guidelines, and there's actually a formula that the court will utilize in calculating a monthly obligation to pay child support. And it comes down to really two things: the incomes of the parents and the overnight parenting time schedule. What can be more tricky within that is determining what the income is. If you have two parents that are W-2 employees and have no other outside employment, it can be a rather simple thing. You look at the W-2 and you know what the income is. If you have a business owner or an entrepreneur, then it can be a little more tricky, but we do have ways of trying to determine what that income is that the court will utilize. It's not the same as what you would put on your tax return. It's a little bit different. But once you have that income determined for both parents, and you know what that overnight parenting time schedule is going to be that Susan talked about, then you input those figures into a formula, and it pretty much tells you what your monthly child support is going to be. Some other factors that you can include in that formula is if one or both parents pays for health insurance through their employment to cover the child. The amount of money spent on a monthly basis for the child or the children will be included in the formula, and it will be rolled into that factor. This formula will also tell us what responsibility each parent has to pay the uninsured medical expenses for the children. So when you have to go to the doctor and pay a $10 copay, both parents are technically responsible towards that. You might be 50% responsible, or one parent might be 60% or 90% responsible, but this formula will tell us what the obligations are for each parent. For daycare, we can't, I'm sorry, yeah?
It looks like we just had a question come in
Oh,
related
sure.
to parenting time. What if my spouse only wants more parenting time in order to reduce his child support obligation?
And that has been known to happen. I can't say that it doesn't happen. We do have to consider also, the best interest of the kids. That's what the court's looking at. The court is not looking at this regarding child support factors. They're looking at this regarding what's best for the kids. So if one parent who happens to travel significant amount of time and is away from the house in normal times, a lot of the time, and physically can't actually handle all the parenting time and all the overnight parenting time, it's pretty clear if they're pushing for 50-50 custody or 50-50 parenting time, that they're actually looking at this for more of a break, unless they can actually change their schedule for work. So this is something that the court will look through. The court will actually focus on the parenting time and what's best for the kids, and then they will calculate child support. So it is something that we have to kind of navigate through, but unfortunately, it can happen. The one thing that can happen, if we include the daycare in there, either the parents can, if the children are young, they can include the regular daycare expenses within the formula, so that's actually paid on the monthly basis. Or if the parents so choose, they can pay for daycare separately. Sometimes it can be challenging if there's a daycare figure for the school year and a different one for summer, depending on the age of the children. There is an option for parents to deviate from this schedule or from this child support formula. The courts look at support as really being the right of the child and not the right of the parent. So there has to be a very good reason to deviate from what this formula states. But that can be one area that if somebody is significantly trying to modify a schedule in some way, that we can look at the deviation ability. If you can provide the court with enough reason that the children will be taken care of financially, if there's other areas that the parent will financially care for the child, they will allow for deviation if you can show a really good reason. So that might be something that you can look at and be more creative with, and what other expenses and financial obligations that we have for our kids.
So Susan, what happens in the case where families have a lot of extracurricular expenses for the children? They attend summer camp, they attend private school. Does child support account for those expenses?
Yes and no, Michelle. The child support formula does not dictate to the parent receiving child support exactly how he or she has to spend the child support. It's presumed to cover housing, food, clothing, and all the essentials of life. And by virtue of the formula, which is not something that we're able to just do off the top of our heads, folks often ask, what's the percentage? It's a complicated algorithm that we just put into the computer program. But that being said, the more you make, the more your spouse or your ex-partner make, the more child support you get. But as we all know, kids, kids' needs aren't just based on what their parents make. And extracurricular activities, especially once you're living in two separate households, and suddenly your dollars are stretched thinner, aren't generally covered by the basic child support. And so we try as best as we can to negotiate that as part of the initial child support, because it gets much harder in later years to ask for more than the guidelines. But when you're negotiating it based on what your children have always done, or based on what your older children have done and you expect your younger children to do, it's much easier. So if at the time of divorce, for example, your kids are already in private school, there's a very good chance that we can agree as part of the agreement that for the payment of private school, some division and who and how that should be paid. The same with other school expenses, summer camp, and extracurricular activities, and it really depends on what they are. I know in my experience, some of the more expensive ones, horseback riding, for example, certain traveling sports can get very costly. And if they become new activities 2, 3, 5 years after the divorce, it's much harder to get the court to order that as opposed to the parents just agreeing. But if it's something that the child's already involved in at the time of divorce, we can often get that included as part of the agreement. In terms of college and post-majority support, the court cannot order either parent to support the kids past graduation from high school. Child support goes through the graduation of high school, or 18, whichever is later, but not to exceed 19 and a half. So if you have a child with a late birthday who graduates high school at 17, you will still get child support through high school graduation. If you have a child who turns 18 and is still in high school, you will similarly still get child support through graduation, provided the child graduates by 19 and a half. And this is to prevent, obviously, a child who has no likelihood of graduating just keeping the kid in school in order to get child support. And obviously that doesn't happen very often. But in terms of college and other post-majority support, the parties can agree to put in their settlement agreement or judgment that one or both parents will pay for college. And if you put it in your agreement, the court will enforce it. It then becomes an order of the court. But if you don't agree to it, the court cannot order it. And then finally, what we try to do is provide some kind of security for support. What happens if, God forbid, the parent paying support passes away or otherwise becomes disabled and is not able to pay? We like to secure child support with a life insurance policy, if there's a disability policy, to address that. And we do the best we can to make sure that the parent receiving support has some form of security.
Thank you, Susan. Jen, could you tell us what provisions must be included in a final judgment or order?
Sure. So when you have an order addressing kids, it's important to know that for example, we've done other discussions on divorce. Property division is final and binding once you enter the judgment on divorce. But any issue regarding a minor child, whether it be custody, parenting time, or child support, can be modified at a later date. So long as you are able to prove your burden and you can show the court that there's been a change and it's in the child's best interest. So in order to start that process, of course, you need the final order. And in that regard, for kids, you need specific provisions. You don't necessarily have to have a significant amount of detail, but I do believe, and we do believe, that the more detail you can provide in your order, the better it will be for you and your kids down the road. So of course, once you decide on the custody, the physical and legal custody, you want to include that in there. We do like to include what that actually means. And if you're a joint legal custodian, what does that mean? That means you have the right to access the child's medical records. That means you have the right to attend school events, things like that. So the rights and obligations when it comes to custody. You'll also want to have a very detailed parenting time schedule. It's not required to have the details in there, but it's very highly recommended that you put as much detail as you possibly can regarding your regular schedule, what time are pickups, what time are drop-offs, who's responsible for doing the transportation and things like that. And also be as specific as you can for your holiday schedule. Once you have that order in place, You don't necessarily have to follow that. If both parents agree to changing a little bit or tweaking a little bit here, or saying, I know this is a really important holiday for you this year because maybe it's grandma's last year, you can have it. You don't have to change the order. You can always work together. But if problems come up, if there's a disagreement, then you can go back and follow the order, and you have it written and you know exactly what's expected of you and the other parent. Once you also determine what the child support is and what the breakdown is for uninsured medical expenses and who's responsible for paying daycare, you'll want to include that in this order. There's also additional orders that are required on top of this one regarding the child support. It's called an income, or it's called a uniform child support order. That needs to go in there as well with the judgment. The Hague Convention, this simply states that you can't travel to a country that is not a member of the Hague Convention, and that is regarding international kidnapping. You want to make sure that both parents, when they're traveling internationally, if something happens, that the country that they're traveling to is going to cooperate with the United States government. The domicile.
We had a question just come in.
Mm-hmm.
Can my ex really move 75 miles away and expect my child to get to school on time every day?
So that's the legal residency requirement. There is the requirement that we have to statutorily put in the judgment that neither party can move more than 100 miles away from where they lived at the time the order was entered. That is the bare minimum, 100 miles. You can negotiate before the judgment is entered to reduce that amount. You can't say neither party can move 20 miles away or neither party can move 50 miles away. If someone is going to be moving that far, and that might come into play with some of the post-judgment issues regarding school, if someone wants to move 100 miles away, they're technically allowed to, but that might significantly impact parenting time moving forward. But we do have to put in there that you cannot move more than 100 miles away. Again, you can negotiate. I just negotiated one yesterday, and it was a 30-mile radius, and it was mostly regarding school. Also in Michigan, you have to put in there that neither parent can move out of the state of Michigan. So even though moving to Toledo, if you live in Detroit, is less than 100 miles away, you still can't move to Toledo unless the other parent says, it's okay with me, and you enter a stipulated order, or you take the matter to the court and the judge makes a determination on whether or not that's okay. And finally, the required provisions is the statutory support and no retroactive modification. That means that once the child support is established and it's put in an order, it can't be changed unless the other parent has notification of that. So if you are paying $1,000 a month in child support and it's based on your employment and you lose your job, you need to immediately file a motion to modify child support, because the date that your support obligation will be changed is the date that you file your motion. It's not the date that you lost your job and your income changed. So these are the required provisions, but what Susan said before is also very important, is that if you negotiate those different financial obligations regarding the kids, you have to include those in the judgment in order for the court to enforce those down the road. So if you negotiate college expenses, put it in the judgment. If you negotiate those extracurricular activity expenses, it has to go in the judgment. If it's not in the judgment, it can't be enforced. So while this list is required, the other ones are also personally required for you if you want the judge to be able to enforce those.
Thank you, Jen. Susan, could you tell us what some common post-judgment issues you've seen come up?
Sure. So unlike property settlement, which is final and binding once you are divorced absent extraordinary circumstances such as fraud or misrepresentation, settlements and decrees involving children are always modifiable. And that doesn't mean that the court will modify them willy-nilly. The court wants stability and wants to always do what's in the best interest of the children. But nevertheless, in cases involving children, there's always the ability to go back to the court post-judgment and seek a modification. And some of the more common types of motions we see, just building on what Jen just talked about, the 100-mile rule, what we call a change of domicile or a change of residency. A child can only have one domicile, and if you're generally divorced in the state of Michigan, that domicile is the state of Michigan. A child can have more than one resident, and when parents have joint custody, whether it's joint legal or joint physical, they have a legal residence with both parents. And when a parent wants to move either 100 miles or more or out of state, either needs permission from the other parent or a court order. And to get a court order, you have to go through what's called a Donofrio hearing. Donofrio refers to a New Jersey case that most states in the union have since adopted. And the court looks at whether the proposed move will improve the quality of life for the child and the moving parent, whether the reason the parent is moving is in order to frustrate parenting time for the other parent, whether the reason the parent who doesn't want the child to move is objecting for economic or other inappropriate reasons, and most important, whether once the child and the parent move, if allowed, whether the other parent is going to have the ability to have a close and reasonable, a close relationship and a reasonable parenting time schedule with the child. And those are the factors that the court considers. And the court can also look to whether or not there's been domestic violence, and that's the reason that the party wants to move. And if those factors favor the party moving, the party can be allowed to move. However, in a case, when I go back to bringing up that established custodial environment, if the court finds that by moving, it's going to disrupt the established custodial environment, which it almost always will if the other parent has anything from 30 to 50% of parenting time, the court must also go through all 12 best interest factors. So of everything we do, and I think Jen will agree, these are the most difficult types of motions, and not difficult in terms of the law. The law is very straightforward and we understand it, but difficult in terms of the families. In today's very mobile world, parents lose jobs, parents get transferred. Sometimes you just have to move. Sometimes you remarry and your spouse needs to move, gets transferred. But obviously having a child move away from one parent can be very difficult, but nevertheless, sometimes it's unavoidable. You can't cut the kid in half, and they are motions that we handle frequently. Another type of frequent motion is a disagreement over joint legal decisions. Most common are where the child's going to go to school. And honestly, over the years, I haven't had that many medical decisions. Most parents who have joint custody generally can decide whether a child needs medical intervention or not. The one thing that sometimes there's a disagreement over is vaccines. Of course, that's been in the news over the years. But again, those in my practice, I have found haven't happened that often, because generally parents, when they married, are generally in agreement on, even if they're divorced, on whether or not a child should be vaccinated. But the school motions really come up frequently, most often at the end of August, just before school's about to start, often when the child's turning 5 and about to start kindergarten. Parents have had joint custody for several years, haven't really worried about where the kid was going to go to school. And now suddenly one lives in District A, the other lives in District B, and there's a big fight over which school district the child shall attend school in. It's called a Lombardo hearing because that's pursuant to a case, Lombardo v. Lombardo, where if joint legal custodians can't decide on one of these important decisions, you have a hearing and the court decides. And the court decides based on the best interest of the child, kind of a recurring theme of today's webinar. And then other common motions are motions to modify custody and parenting time. Those are discussing modifications to custody and parenting time can be a whole webinar in and of itself as to what the court looks at and how you are able to modify custody or parenting time. But again, just want to emphasize that involving children, nothing is set in stone. While you have to meet certain threshold burdens in order for the court to revisit custody or parenting time, and it's a higher burden to revisit custody as opposed to just revisiting parenting time, the court can and will do it. And especially as your children age with parenting time, the court recognizes that normal life changes as the children age might require a change in the parenting time schedule. A schedule that worked when your child was 2, 3, or 4 is not probably the best schedule when your child is 9, 10, 11, and then again when your child's a teenager. And it talked about what I talked about earlier, where a 2, 2, 3 schedule, it might be great for a toddler, but not so much for a teenager. And then, as Jen mentioned, modifications of child support, not only because of losing job or changes in income, but also every 3 years, you're actually entitled to a statutory review of child support just based on inflation, changes in the guidelines, changes in the economy. And finally, another frequent motion is just a motion to enforce whatever agreement you reach. Your spouse is supposed to pay for half of all extracurriculars, and he or she has stopped doing that. Your ex-spouse is not facilitating parenting time, is keeping the child from you. I mean, the list goes on and on. Whatever agreements you reach in your judgment, or whatever the court orders in your judgment, not by agreement, but by trial, if your one party is not living up to those agreements or orders, the other party can file a motion to enforce.
Thank you, Susan. At this point in time, we're going to open it up to questions and answers. So please submit your questions through the Q&A at the bottom of your screen. We do have some questions that were submitted already, so I will go through those now, but please keep them coming. So Jen, could you please help us with this one? My friend told me that the courts favor mothers in custody and parenting time decisions. Is that true?
No, I don't think it's true. It is important to remember that every judge is, judges are people, so every judge has their own opinion and their own belief system. Every county is a little bit different, and every area of the state is a little bit different. The most important thing to remember with any family law case, but in particular issues regarding kids, is that no two cases are alike. You have different circumstances regarding the kids, you have different parents involved, you have different attorneys involved, and then you have the judge. So it really comes down more to the circumstances of your own particular case. And as much as you can kind of compare the emotionality of going through a divorce or a custody matter, no two cases are alike. And your case isn't necessarily going to be like your friend's case or your cousin's case or your neighbor's case. It really comes down to you, your spouse, your kids, and the judge and the attorneys involved. So I can't say that anymore that one gender is favored over another gender. Pretty much judges have their own opinions moving forward, and they look at really what the dynamics are of each family.
Thank you. Susan, what is a parenting time coordinator?
Oh, that is a good question, something we didn't discuss. So going back to how Jen started this, about that we always want to try and settle, and it's always best to stay out of the court. Many judges will look you in the eye and say, I'm a stranger. Why would you want me making decisions about your children and your family? And the friend of the court will tell you about the thousands and thousands of cases each referee has and how little time they have to devote to your case. But sometimes you just can't get along. And one tool we have is to appoint a parenting coordinator, which is usually a lawyer, a neutral lawyer, who will help you navigate questions, issues involving your children. Usually the coordinator's appointed for a year. There's a statute, and that he or she, the recommendations can be binding or non-binding. And basically it's a mechanism for resolving issues, usually without attorneys, in order to avoid going to court, and have someone help you navigate the post-judgment world, the immediate post-divorce world of co-parenting.
Thank you, Susan. It looks like we have one last question here. Jen, could you help answer this one? What if my child refuses to go with my ex for parenting time? What do I do?
That's a tough one, and it's something that a lot of parents do face at any given time during the process. I think a lot of it depends on the age of the child and what's going on, and the relationship that you have with your co-parent. The best thing that I can suggest that you do is first to make sure that the child is safe, that they're not concerned about some physical danger. But usually that's not the case. Usually the child is just having a rough time, or they're having a bad day, or they don't like going to dad's house because he buys the wrong pizza, or they don't want to go see mom because she doesn't have the right Nintendo set. So it's really trying to encourage the child, foster that relationship with your child and their other parents. And if you can, communicate with the other parent and say, hey, it's a rough day. Can you come a little bit later? Can we maybe do it on a different day? But you want to be really cautious on how you communicate that to the child. And as much as you can, support the child's relationship with the other parent. If they're having a disagreement with the other parent, try and talk that through and say, hey, why don't you sit down and talk to them? It's a really difficult thing. And if kids are going through a rough time, I'm a strong proponent of trying to get the kids counseling. Kids going through divorce cases, and even later on in life, if they've been through a divorce case, they just need someone to talk to and to have a neutral third person that they can go and sit down and mull things over and try and problem solve can be a real significant help. And it might help them build up some coping mechanisms and some strategies for moving through these difficult times. So that's one thing that I do encourage a lot of people to do, is try and secure that counseling for their kids, and to really just know that your kids are going through a rough time, and try and work with them and figure out what's going on and encourage them to go see that other parent.
Okay, thank you, Jen. I don't see any other questions, so thank you everybody for joining us today. If you do find that you have additional questions, please feel free to reach out to us. Our contact information is provided on the screen in front of you. You will also be provided with a copy of today's presentation, and a recording will also be available on our website on demand within a few days at jaffelaw.com. You will also receive a survey for your feedback. Please fill it out, as that is important to us. We really want to hear back from you. And in case you are interested and missed our previous 2 webinars, recordings are available on the website. Those webinars were on nuptial agreements and the basics of divorce. We look forward to launching additional family law webinars in the spring. Thank you for attending and have a great day.
Goodbye, everybody. Stay safe.